One of the most vulnerable segments of our society that needs protection and access to employment and all of the benefits of society is the disabled community. Since the mid-1980s, California law has protected disabled people against denial in both accommodations, that means access to public and private places, as well as to employment. And it's the employment area that I want to speak about particularly. Under California law, if you are disabled, which means that you are limited in your ability to engage in one or more major life activities, such as walking, breathing, working, anything that affects a major life activity, or you suffer from some sort of systemic disease or problem such as diabetes, high blood pressure, any one of these common phenomena that affects your life systems, then you are entitled to what's called a reasonable accommodation if it will allow you to perform the essential functions of your job. So what does all that mean? If your job is to engage in a particular activity, and that job can be accomplished with some accommodation that is reasonable, something that can be given to you, an adjusted work schedule, a realignment of your workstation, a stool instead of having to stand, if you're visually impaired, a larger monitor, if you're deaf, a TTY or other device, if you're blind, a braille reader or an auditory reader, if you're in a wheelchair, a ramp, a modified desk, if one of these or any other type of accommodation can allow you to perform the essential functions of your job, your employer has an obligation to provide it to you so long as it doesn't create an undue financial hardship on the employer. Now, the employer has another obligation, and that is to engage in what we call a good faith interactive process. That means when the employer becomes aware, either through you telling them or based upon observing that you're having a difficulty. I mean, if you're in a wheelchair and you come into an office space, you don't need to tell them, I'm disabled. But once your employer has a reason to believe or you've informed them of your disability, they must engage in a good faith interactive process to sit down with you, to talk with you, to find out what types of accommodations can help you be a productive member of the workforce. Now, an employer has certain rights. An employer may have the right to ask you to have a medical evaluation to find out what accommodations you may need and to certify that you're disabled. A very important thing. No employer can do this before they've given you an offer of employment. So an employer must make a decision on employment based upon merit alone. Once they've made that decision, if you need an accommodation, then they may be able to ask the questions about the disability and how it will affect your ability to work. The time has come for discrimination based upon disability to stop. We see it a lot, we deal with it directly, and we help change not only the lives of our clients, but the practices of these companies so that it never happens again.